My name is Carolyn Toohey, and I'm a Professor Emeritus of Political Science and Distinguished Fellow here at the Munk School of Global Affairs and Public Policy. And it is my distinct pleasure to welcome you to the annual Cadario Visiting Lecture in Public Policy. Before we begin, I would like to acknowledge the land on which we live and work. The University of Toronto operates on land which for thousands of years has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. I would ask each of you to reflect on the meaning of the traditional lands on which you find yourselves today. The Cadario Lecture is one of the signature offerings of the Munk School, made possible through the abundant generosity of Paul Cadario. Paul is a distinguished fellow at the Munk School, and he brings to us not only the benefit of his experience in a long and eminent career at the World Bank, but also a deep curiosity about the world and an incisive mind that inspire this lecture and much else at the Munk School, where he is an engaged member of the community. Thank you, Paul, for all you do for us and especially for endowing this lecture. It is now my very great pleasure to introduce our speaker for this academic year, Professor Kathleen Thalen, Ford Professor of Political Science at MIT. The Cadario Lecture is meant to bring to U of T scholars who are bringing deep and original scholarship to bear on our understanding of crucial policy issues and questions of the day. And there is no question that as we live through this critical moment and try to contemplate what lies ahead for advanced capitalism and democratic governance, Kathy Thalen is one of the scholars leading the way. When you think, for example, about how Uber, Google, Facebook, and other practitioners of so-called platform capitalism have been able to amass such power, you might not immediately think of looking to developments in the late 19th and early 20th centuries for an explanation. But Professor Thalen's work shows us how the capacity of our institutions to generate and to address present challenges lies rooted in a long course of historical evolution. As the title of her talk suggests, history casts a long shadow. That's true whether we're talking about platform capitalism or precarious work or the ability to mobilize collective resources in response to collective shocks like COVID-19, each of which Kathy has explored in recent work. So many of these challenges come down to the distinctive ways that capital, labor, and the state have been organized in different political economies, the enduring focus of Kathy's work. Kathy Thalen is one of a select group of scholars whose work has essentially defined the field of historical institutionalism in political science. Her stature within the discipline is reflected in numerous honors, including the Aaron Wildavsky Enduring Contribution Prize from the American Political Science Association in 2019, and her election to the American Academy of Arts and Sciences in 2015, and to the Berlin Brandenburg Academy of Sciences in 2009. She holds honorary degrees from the Free University of Amsterdam, the London School of Economics, and the European University Institute in Florence, and the University of Copenhagen. I would say that we could not be happier that she is joining us today, but that would be wrong. We could be happier if she were with us in person as originally planned. But a virtual Kathy Thalen is still a great treat, and we look forward very much to hearing from her today. After her talk, Professor Thalen will have a short conversation with the Munk School's moderator par excellence, my friend and colleague, Professor Peter Loewen. Peter Loewen is a professor in the Department of Political Science and the Munk School of Global Affairs and Public Policy. He's also the Associate Director, Global Engagement at the Munk School, Director of the Policy, Elections and Representation Research Lab, a Fellow with the Public Policy Forum, and overall one of the liveliest intellects you are likely to encounter. After his conversation with Professor Thelen, Peter will moderate a Q&A with the audience. And with that, let me warmly welcome Kathy Thelen and turn the screen over to her.
Well, thank you so much, all of you, and Carolyn, for that extremely generous and warm introduction. It would have been indeed a lot nicer to be with all of you in person as originally planned, but I'm happy that we were somehow able to make it work anyway. And I want to thank everybody who's on the call for taking time for yet another Zoom meeting, and I think that's taking time for yet another in the midst of all of this sort of Zoom fatigue. So, as some of you I think know, I've been working a lot more lately on the American political economy, and this is an interest that really does grow out of the work that Carolyn was talking about. On these new big platform firms like Uber and Amazon that now occupy such an important place, in the global economy, but in particular, of course, in the American political economy. But my interest in the American political economy is also flowing out of work that I've been doing recently with some actual Americanists. I'm a comparativist by training, of course. But I just finished an edited volume together with Jacob Hacker, Paul Pearson, and Alex Hurdle-Fernandez that's coming out with Cambridge later this year. And the chapters in that volume sort of bring together Americanists with comparativists to try to shed some light on important features of the contemporary American political economy. And the more I have been working on the American political economy, the more I've been struck by really some of the quite distinctive features of this system. And so in the meantime, I'm working on a solo book in which I'm exploring some of the historical origins of some of these more distinctive features. As Carolyn points out, I'm always sort of finding myself thrown back to the 19th century. So the piece of this that I want to give you today concerns the way in which American employers are organized and the pretty distinctive strategies that they've developed to advance their interests and the implications this has had for the operation of the American political economy generally, and for some of its really deeply inegalitarian features with which it's so associated. So I'm going to share my screen at this point. I hope that's visible to everybody. And this, I'll just say, this is very much still work in progress. So I am really eager to hear your reactions. So the title is American Employers in Comparative Perspective, Historical Legacies in the Long Shadow of the Law. So from the comparative, whoops, I'm not getting, it's not advancing.
AV support here, Kathleen. If you just click on the screen with your mouse, it should advance the slide for you.
Okay, there we go. Okay, so from the comparative research, we know, of course, that a strong labor movement is really crucial to achieving high levels of economic equality and shared prosperity in post-industrial political economies, right? So this chart is simply showing what you already know. It's just recording levels of union organization across a range of different countries. And obviously all I want you to see here is that the most egalitarian countries in the world, the Swedens and the Denmarks, they all have very high levels of union membership. However, what we also know is that these highly egalitarian countries don't just feature strong unions. They also feature very strong and highly centralized employer associations. And that's what you see on this slide in the red. And of course, one of the things really that the comparative political economy literature has taught us is that durable progress is really only possible where strong unions are able to strike deals with strong and encompassing employer associations. So just to take a sort of obvious example, the kind of encompassing sectoral, or in many cases multi-sectoral bargaining that we know supports higher levels of wage equality is really only possible, of course, when organized labor has a counterpart on the employer side with whom to bargain. But what we also know, of course, from the comparative literature is that strong employer associations are important for other reasons, among other things, for the way that they can facilitate cooperation on a bunch of other matters, things like worker training or research and development or standard setting. These are the kinds of things that support competitive strategies that are based more on quality rather than on simply price or wage competition. These are the strategies that are, of course, much more associated with Europe's more, quote unquote, socially embedded variety of capitalism. So in the comparative literature, the United States, it turns out, stands out not just for the weakness of its unions, but also for the weakness of its employer associations. So in the dominant varieties of capitalism framework, of course, this is kind of a key defining feature of liberal market economies generally, the idea that employers lack the capacity to coordinate their activities through arrangements that could allow them to achieve joint gains through cooperation. So in many ways, the varieties of capitalism gives us a characterization of what employers in liberal market economies sort of can't do, or what they don't do, the capacities that they lack. But that picture of sort of uncoordinated employers that we take from the comparative literature seems somehow out of sync with the picture that emerges from an alternative Americanist literature on organized business, including by some of my co-authors whose books are on the screen here, which paints a picture, a very different picture of a really pretty self-conscious, powerful business community that's been rather successful in successfully pushing back at some of the advances, especially the regulatory advances of the 60s and 70s. So this paper is an attempt to kind of reframe the issue. The question is not so much, are business interests capable of coordinating among themselves, but rather I'm asking, what kinds of collective capacities have American employers developed? What exactly are they organized to do? And just to kind of preview, the subtitle of this talk, of course, is The Long Shadow of the Courts, because the judiciary is going to figure very centrally in my argument. And so to preview the argument, the punchline is that I'm going to argue that the courts in the late 19th and early 20th centuries played a really important role in pushing American employers away from collective action in product and labor markets, the kinds of coordination that figure very prominently in the varieties of capitalism literature, pushed away from that and toward alternative strategies organized around exercising political influence and especially influence through litigation. So some of you may be familiar with the work of the wonderful legal historian Willie Forbath, who did a terrific study of the role of the judiciary in explaining the structure and the strategies of the American labor movement, right? And you can think of this paper as a kind of companion to that argument, because I'm going to be suggesting that the courts also had a really profound impact on the organization, the goals, and the strategies of American employers as well. And this is something that Forbath obviously doesn't explore. So a comparative perspective is always, I think, useful for identifying what's distinctive about the United States. And so here I'm going to lay out my argument through a comparison to Germany. So let me just start by sketching some of the differences in the landscape of business organization in Germany and the United States today. Okay, so this is kind of the outcome that I want to explain. And the differences are indeed pretty striking because German firms are embedded in a very rich associational landscape of very centralized, very robust employer organizations. So first of all, every firm is a member of one of 79 compulsory affiliates of a national chamber of industry and commerce. which among other things oversees and actually administers a nationwide system for vocational education and training of workers. Second, German firms also typically belong to one of about 40 very encompassing industry or trade associations. These trade associations cover very big sectors, things like all of mechanical engineering. And these associations provide their members with a bunch of collective goods, things like joint research and development, joint standard setting, assistance in international markets and the like. And finally, a majority of German workers are employed in firms that belong to a very small number of overarching national employer associations that negotiate with labor, again, on a very broad sectoral basis. So the associational landscape for business in the United States is very different. It's pretty thin, and above all, it's highly fragmented. So first off, we have over 10,000 local and regional chambers of commerce, but each of these things is wholly independent of the others, right? So each of these individual chambers is typically entirely parochial in orientation, doing things like providing networking opportunities for local business people or advocating generally for local development. The National Chamber of Commerce in the US does not at all coordinate the activities of these local chambers. In fact, many of these local chambers are not even affiliated with the National Chamber. Second, we have thousands of trade associations, but the vast majority of them are organized around a very narrowly defined sector. Things like the Envelope Manufacturers Association, or the Pellet Fuels Institute, or the Mulch and Soil Council. These things are typically very small. Some of them have no staff at all. The median number of staff for the entire landscape is 4. And again, they're mostly involved in kind of social networking types of functions, things like distributing a newsletter. And then finally, of course, we have no overarching employer association in the United States that is capable of bargaining collectively with labor unions. On the other hand, what American employers do have and what employers in Europe tend to lack, certainly in the form that we have it in the US, is a set of very powerful and very well-funded sort of general purpose organizations, things like the Business Roundtable or the National Right to Work Committee or the United States Chamber of Commerce. And they are indeed very well organized and powerful, but they are not organized around or not focused on the kinds of coordination that figure so centrally in the Varieties of Capitalism literature. Instead, they're focused on exercising political influence, of course, through the usual lobbying and campaign finance activities, but also, and I would say pretty distinctively in the US, on exercising influence through the courts. For example, they're very deeply involved in judicial elections and all kinds of appointments to the bench, actually. And they're also very heavily involved in direct litigation on behalf of business interests at all levels. So my question is basically, how did we wind up here? And the claim again of the paper is that events of the late 19th and early 20th centuries played a really important role in pushing American business away from forms of collective action that we find in Europe that were designed to assist firms in the market, and that I have to emphasize were very much also present in the United States in the late 19th century. But it actively disarticulated those arrangements while at the same time encouraging employers to focus really a lot of energy and an organization around exercising influence in politics and especially in the courts. Okay, so the United States and Germany, of course, differ on a whole bunch of important dimensions. I'm not going to try to sort of say that they were exactly parallel to one another, but I will say that they shared some pretty important and striking similarities in exactly the period that I'm focusing on. So let me just tick off a few of them. You know, the first point is that a lot of the literature on American exceptionalism tends to focus on labor rather than my focus, which is on employers. And part of it is suggesting that, you know, American unions faced a really unusually high level of state repression at the turn of the 19th to 20th century. But, you know, repression was a huge problem in Germany too. Germany wasn't even a democracy at the time. Germany was an authoritarian country. And so unionization rates in the two countries were pretty close to one another, around 5% in both countries at the turn of the century. The two countries also had very similar levels of industrial development. You had about a third of employment in manufacturing and about a third of employment in agriculture at that time. And then finally, and really most importantly for my argument, in both of these countries, the closing years of the 19th century were a period of really extreme economic tumult. You had a deep depression that was creating sort of overcapacity in a wide range of manufacturing markets and setting in motion really vicious cutthroat competition among firms, which in turn, of course, then provoked a lot of industrial strife. So in both countries, this period saw a flourishing of new associational forms as firms sought to kind of cope with these new market conditions. One development, especially in capital-intensive sectors like iron and steel or chemicals, was of course the formation of trusts in the US or cartels in Germany. These are these arrangements through which big companies form various kinds of combinations to reduce competition among themselves. This is, of course, the phenomenon that's most familiar to most people, and it's certainly the most heavily studied, not least because it really involved in many ways innovations, you know, the innovation of wholly new corporate forms. But those sorts of strategies were not available, or they weren't attractive to a much larger number of independent manufacturers, often, but not always, smaller firms like the machine shop that you see in this picture, but many other sectors as well. And these firms too developed cooperative arrangements to try to head off this ruinous competition among themselves to try to survive in these more volatile markets. So in the case of these smaller independent producers, the cooperative arrangements that they were developing really were not new innovations at all. They grew really much more out of informal arrangements that had existed in both countries in the 1860s and 1870s, certainly. I used to think that the guild tradition was a really important precondition for high levels of employer organization in coordinated economies. But in the meantime, I've really learned that there was just a lot of coordination going on among small industrial firms in the United States as well. It turns out that markets in this early industrial period, really in both countries, very often involved a really complicated and interesting mix of competition and also coordination, right? So a lot of industry in the 1860s and 70s in both countries involved sort of regional clusters. So for the US, for example, Detroit was a big hub for the machine industry. I think that's where this picture is actually from. So the small industrialists who were in these areas, they certainly competed with one another, but they also, knew one another. They hung out together, they socialized, they went to the same churches, and they exchanged information, including information about some of the common adversaries that they faced, like unreliable suppliers, or they would grouse about high transportation costs, or exchange information about customers who were trying to play them off against one another. Chandler actually talks about this. There were just all sorts of forms of collaboration and cooperation among independent firms and pools all over the place in the 1870s and 1880s. There was nothing sneaky about this. They were not always effective, but they were certainly operating out in the open. The problem that they faced in this period was that these sort of informal forms of coordination that they had developed were really coming under tremendous pressure and quite dramatically in the context of this downturn in the late 19th century. So it was in this context that there were moves, again, in both Germany and the United States to kind of formalize these arrangements as a way of shoring them up so that they could try to head off this destructive competition that they were facing in this period. So in both countries, the courts played a really important role in developing very divergent responses to these new economic constellations that were emerging and being institutionalized at this time. So in the US, of course, the Sherman Act was critical, but the law was famously ambiguous, right? It simply outlawed combinations that acted in restraint of trade and then kind of left it to the courts to figure out what that meant. And the early years of its enforcement turned out to be, of course, highly uneven. So so-called loose combinations, these arrangements between independent firms, they were increasingly held to be per se illegal, right? Despite actually many common law precedents. At the state level, there were all sorts of precedents that combinations were okay, so long as they didn't prevent competitors from entering or result in monopoly. So there had long been a kind of distinction between so-called reasonable and unreasonable restraints in trade. But especially, even before, but especially after the Sherman Act, no such distinctions were getting made. All of these arrangements were simply seen as constituting a restraint of trade. By contrast, the courts, of course, exercised a whole lot more forbearance when it came to so-called tight combinations. In other words, these new forms, new constellations formed by trust or merger, because here the court was requiring proof that the so-called evident purpose of the combination was to restrain trade. So Posner's analysis documents the resulting pattern, and basically what it shows that is that in the first 2 decades after the Sherman Act was passed, it was mostly these horizontal combinations among independent companies that were sort of getting prosecuted. And this uneven enforcement of antitrust is, of course, why the US experienced this huge wave of mergers in this period, because, of course, the surest way to avoid running afoul of the law was through merger. So this was the period in which thousands of small firms really vanished into larger companies in this period. So that by the early 20th century, fully 100 industrial fields were dominated by a single firm. The courts were also really crucial in Germany. Actually, in some ways, unlike in the US, there was no legislation on cartels in Germany until the 1920s. So in some ways, the courts were even more consequential. It was sort of entirely up to the courts to figure out how to deal with these new arrangements. However, in Germany, the courts steered the country toward a very different approach to competition policy by embracing the notion of a so-called managed market, one that would allow and even in some ways support these forms of coordination, horizontal coordination among independent firms that had developed. So the idea here was that competition could be organized, but it also should be, of course, monitored. So the leading legal scholars in Germany, including the guy on the slide here, Schmoller, were vehemently anti-Marxist, but they also rejected the kind of unbridled, atomistic competition that they associated with the alternative sort of Manchester liberalism ideology. They basically thought that leaving things to sort of unmediated market forces could well drive destructive competition, what they called a wild war of all against all, and nothing good could come of this. And I just want to kind of pause here to underline that in many ways the German approach involved a much the German state was arguably much stronger, but the German approach in this area arguably involved a much lighter touch when it came to state intervention in the market, right? We think of, pure competition as the kind of natural state of affairs in the market. But of course, the way that things had developed among these independent producers in the mid-19th century was much more characterized by this interesting blend that I was just talking about of competition and coordination. And this was something that the German courts were sort of recognizing and indeed sanctioning. But this is the situation that the US courts were actively disrupting by insisting on a sort of idealized notion of a market that was based on this pretty strong binary between pure competition or collusion. So I just want to underscore that what was changing here was the law and not the behavior of these firms, because it was the courts that were sort of compelling these firms to compete based on a notion of how they thought the market really should work. So the centerpiece of Germany's managed market ideology held that economic actors, were fully entitled to engage in collective self-help to protect themselves against the ravages of the market. So the German courts were exercising not just forbearance, but they were actively supporting these arrangements in various ways. They were enforcing contracts that these big cartel members were making with one another, but also, and more important for my argument, and more different to the US, clearly, is that they were also extending this policy of forbearance toward associations of small firms, these loose combinations. So the activities of these small independent firms that were illegal in the US context were absolutely fine in the German context. So as these arrangements came to be more and more institutionalized, formal cartels of all sorts and sizes, not just these big capital-intensive companies, were getting institutionalized. So according to the Interior Ministry, there were 385 registered cartels already in 1902, and the numbers only continued to increase. And for me, most remarkably, and certainly most different to the United States, and in some ways, I would say most surprisingly, given that Germany's an authoritarian country and persecuting socialists during part of this period, Germany's imperial civil court extended the same rights of collective self-help even to combinations of workers, right? So the regulation of competition law was a matter of civil law in Germany, and the imperial civil court was upholding all sorts of behaviors that were getting outlawed in the United States, things like boycotts and secondary actions. These were things that cartels were, of course, using to exert pressure on firms outside the cartel, but they were also things that were being used by unions to try to force employers to bargain. All of those activities were considered by Germany's imperial civil court to be absolutely legitimate acts of collective self-defense against the free play of market forces. So in terms of outcomes, I've already alluded to the impact of these different competition regimes on large firms in the US. As a big literature shows, it indirectly promoted mergers and growing concentration. And in Germany, it actively supported these large cartels. But more important for me, it also supported these forms of coordination among these independent, often smaller firms. And this is important because this is exactly when virtually all of Germany's powerful trade associations, the ones that I mentioned on that earlier slide, this is where they all get their start. And so these nascent trade associations among independent producers, they were specifically organized around coordinating on things like production strategies, technology, some patent sharing, and so on. Not so much to eliminate competition, because they were still competing, but to manage competition among themselves in the market. So a lot of this was basically information sharing And one of the roles that the trade association itself would play was to provide training. For example, training to firms in cost accounting, because a lot of destructive competition among small firms in these, or even medium-sized firms in this period, was caused because these firms really didn't have a systematic way of calculating the actual costs of their own production, so that they would sort of inadvertently underbid each other or bid each other down because they were underestimating their own production costs. So I put Gary Herigel's book on the screen here because his work documents some of the most successful cooperative arrangements that were really flourishing in Germany in this period. And his focus is on specifically on regions and industries in Germany that relied heavily on skilled workers. And the firms in the regions that he looks at are not so much, engaged in price fixing like the big cartels. Instead, they were doing things like establishing term fixing cartels, where they would establish shared guidelines for payment and delivery schedules to basically prevent firms from kind of destroying one another by offering to perform services on increasingly, unreasonable terms, often prompted by customers sort of playing them off against each other. They also did things like specialization cartels, where member firms would kind of divide up the market by agreeing to specialize in kind of different product lines. So these arrangements in turn provided a space within which it was safe for these member firms to contribute to building and maintaining complementary institutions of collective self-help that would benefit all of them. These are things that I've talked about in some of my other work, but things like vocational schools to cultivate and expand the local skill base, or joint technical institutes to facilitate the dissemination of the latest technologies. And because these firms were not competing with one another on labor costs, and because they often relied on skilled labor pretty heavily, they were far less opposed to working with unions than the big capital-intensive cartels that mostly employed unskilled labor. So these areas of decentralized but coordinated production that relied on skills are also the areas where collective bargaining with unions first took root. Actually, bargaining with unions was pretty helpful to them because that would also sort of forestall bidding wars among firms for skilled workers that would otherwise drive wages up. So American industrialists also developed all of these forms of cooperative arrangements. Again, this was very common in the 1860s, 70s, and even into the 80s, but they met a quite different fate. So these arrangements, which were often sort of originally regionally based, had already come under a lot of pressure as a result of advances in communication and transportation that introduced more interregional competition. And of course, those pressures only increased pretty dramatically with this downturn in the late 19th century. Just like in Germany, you had sort of more formalized arrangements of trade associations emerging across a range of sectors, doing many of the same things that their German counterparts were doing to stabilize competition through information sharing, through some sort of coordination on prices, and especially on production. However, the more, in the US, the more these associations responded to these new pressures by formalizing these cooperative arrangements, the more they wound up in the crosshairs of the courts. So while their German counterparts could coordinate, legally and openly, American trade associations, particularly after the Sherman Act of 1890, had to rely really virtually entirely on voluntary cooperation. But of course, voluntary cooperation is fragile to begin with, but especially so in the context of these intense competitive pressures where the incentives to engage in opportunistic behavior were more or less irresistible. So independent manufacturers in the United States had two responses to their inability to legally coordinate openly among themselves. One response, which was specifically spearheaded by high quality firms in sectors that relied heavily on skilled labor was basically to enlist unions to help them solve their collective action problems. For these firms, so these are firms in which labor cost was going to make up a huge part of their overall production cost. And for them, it was very helpful, or unions could be very helpful, because they could enforce minimum standards for wages and working conditions. So you had unions, like I put the iron molders on here because the iron molders had one such especially successful agreement. You know, the unions like the iron molders were more than happy to oblige, because they too had a strong interest in eliminating firms whose strategies basically relied on labor sweating. It's kind of hard to imagine today, but by the end of the 19th century, in the US, you had fully 26 either national or very large district sectoral agreements across a range of industries. In other words, American employers were developing and institutionalizing all these forms of coordination, both coordination among themselves, but also in some cases to negotiate with unions. So that entire process of institutionalization, though, was short-circuited because of the intervention of the courts. And a very important kind of key player here was the American Anti-Boycott Association, the AABA. So the AABA was a really interesting organization. So firms could join this organization, and of course, member firms paid dues, but the membership was secret. You couldn't, it was all confidential. And it was not an employer or trade association in the way that in any way, shape, or form. Instead, it was basically a network of lawyers, right, led by this guy, Daniel Davenport, who's on the screen, who was the organization's general counsel, who basically led a small team of lawyers who would litigate on behalf, in this case, of small, sort of low cost, low quality producers that were disadvantaged by especially these negotiated agreements that were emerging in this period, right? So the AABA offered legal advice to its member firms, but much more importantly, these lawyers directly sponsored and spearheaded litigation on behalf of business interests writ large. And in this, the AABA was extremely strategic, right? Davenport declined cases that the association thought were weak or could set a bad precedent. And he actively sought out cases that he and his his fellow lawyers saw as capable of establishing national precedents positively for business. Very much actually like the Chamber of Commerce's litigation center today. The AABA was wildly successful. It won every single one of the cases that it took in the first 5 years of its existence. And the most famous, and I would say the most consequential, was of course the landmark Danbury Hatters case, Lowe v. Lawler, that basically extended the application of antitrust laws to labor unions, right? This is a decision that effectively precluded the development of industrial unionism in the US. So very quickly, all of these sectoral agreements that I was just talking about collapsed. And some of the more prominent peak associations, outfits like the National Association of Manufacturers, which previously had been extremely tolerant toward unions, not least because their big issue was tariffs. And on the tariff issue, they were very much on the same side with labor. But at this point, outfits like the National Association of Manufacturers began working hand in glove with the AABA to use the courts to assist individual firms in avoiding unions. In fact, one of the next really big cases that the AABA brought and won was on behalf of a firm that was owned by the president of the National Association of Manufacturers. So the impact of all of this on unions is, of course, well known. That's exactly what Forbath's work has so well illuminated. But for my purposes in the present context, the point is that the Danbury Hatters case and the success of the AABA generally basically relieved employers of the need to coordinate among themselves to fight unions. Instead of having to sort of collaborate, you basically could just hire a lawyer. This is not the end of the story, though, because a second strategy that these independent firms in the United States developed took the form of a political movement to try to soften some of the legal constraints that they faced. And this took the form of the American Fair Trade movement of the teens and 20s. So we tend to associate, or I used to associate, the progressive era with a more aggressive prosecution of big monopolies, and there was certainly some of that sort of toward the beginning, though less than you would think, perhaps. But there was something else quite different going on as well during this period, especially when it came to these horizontal combinations among independent firms and trade associations, right? So those firms, of course, noticed that the Sherman Act was getting applied pretty differently to them than it was to the big firms. And so they mobilized to demand that the courts assume a more nuanced stand with respect to their associations, right? Similar to the so-called rule of reason that in the meantime was getting applied to the big vertical combinations, particularly after the 1911 Standard Oil case. So the idea here, really similar to Germany, was that there was healthy competition, but there was also unhealthy competition. And what these firms were trying to do was to avoid unhealthy competition among themselves, to allow them also to survive, but also to compete with some of these big firms that had emerged by establishing so-called fair trade standards. So some of the most influential legal scholars of this period, including Louis Brandeis himself, endorsed this whole movement. Brandeis himself was partly inspired by developments in Germany, which he was actually following through research that his sister-in-law was doing. And he and other progressives endorsed these fair trade codes and really advocated for the extension of rule of reason doctrine to these kinds of trade associations as well. So this movement gains a foothold at the national level in the progressive era with the establishment of the Federal Trade Commission in 1914. In fact, the National Chamber of Commerce, the US Chamber of Commerce, the very same organization today that is always pressing for deregulation, actually played a really important role in coordinating some of this. The chamber was an active participant in so-called trade practice conferences that were getting convened by the FTC. These are forums for firms within a particular industry to sort of come together and share information and set norms and standards. And also they were providing training in this cost accounting, doing things, in other words, very similar to what German trade associations had been doing for quite some time. Generally, the idea was to steer competition away from cutthroat pricing to competition based more on quality, more on innovation, really as a way of sort of promoting continuous improvement among these producers, and in that way kind of forestalling further concentration of power within particular industries. So new legislation on competition policy in this period, the Clayton Act, which was passed in the same year as the FTC was created, was supposed to provide some sort of cover for these activities by drawing more of a distinction between constructive and destructive competition. But again, the boundaries between these various categories was completely sort of vague. And again, it was up to the courts to kind of figure all this out. And the problem here was that the Department of Justice and the judiciary were still operating on the basis of this very strong binary. Either you had sort of pure competition or you had collusion. This idea of a managed market or regulated competition just did not resonate. Moreover, the judiciary at this time, of course, was viewing this entire emerging administrative state, including, of course, the FTC, with a lot of suspicion. They were just not interested in giving up the kind of privileged position that they'd occupied in terms of the governance of economic activity. Gary Gerstl's work is really good on this. He shows how the new administrative state in the US sort of didn't so much, displace the pre-existing kind of court-based policymaking regime. It sort of grew up alongside of it or embedded in it and in a lot of tension with it. So the courts had basically given these trade conferences and trade associations a pass during World War I, not least because these associations were really helpful in managing wartime production. But as soon as the war ended, the courts started shutting these things down. There are many cases here, but one of the more important cases was one brought by the Department of Justice in 1921 against the American Hardwood Association, which was actually one of the more successful trade associations. And what they had been doing, among other things, was collecting and disseminating cost and production statistics, disseminating these statistics to member firms to help them avoid sort of excessive competition. And in this case, the Supreme Court held that even this kind of exchange of information was illegal under prevailing antitrust rules. So that sort of put the kibosh on a lot of these trade associations. Brandeis, in the meantime, was himself on the court, but he, of course, was part of the minority and in dissent on that case. So many of these trade associations kind of limped along in the context of what was really sort of high legal uncertainty and sometimes periodic harassment by the courts. Basically, that was the end of really meaningful coordination on production issues, at least. And this is when these trade practice conferences also kind of petered out. So just to conclude, there's, of course, a huge literature on American exceptionalism, but as I said earlier, most of this work really focuses on the question of what's different about American labor. Why are American unions so weak? Why are they so conservative? Why no socialism compared to their European counterparts? But I think the focus on labor in many ways kind of overlooks the possibility that what's exceptional about the US may also have a lot to do with what's distinctive about American employers. And so my point here has been that these developments in the late 19th and early 20th centuries really left a pretty enduring impact on employer organizations and on employer strategies in the US, and with that, really on the subsequent development of the entire political economy. So thanks to or no thanks maybe to the actions of the courts in this period, the US sort of winds up with the worst of both worlds. You had a competition regime that at this critical period really promoted industrial concentration without, however, supporting any of these other potentially more beneficial forms of coordination. In fact, if anything, it kind of snuffed them out and left this a legacy of this kind of fragmented landscape of employer organization that I showed you at the beginning. Beyond that, though, I think another of the pretty important legacies of this period is that this is when American employers began to invest extremely heavily in cultivating capacities to use the courts to achieve their objectives. We think of certainly American business as mostly wanting to get the state out of the market, but much of the business lobbying that was going on in this period, not least by the National Association of Manufacturers, was precisely focused on keeping the courts involved, at least involved in the area of labor relations. And so this is also the period in which these business organizations, or at least their lawyers and litigation departments, really developed and perfected a bunch of the legal arguments about individual liberty, freedom of contract, and so forth, that still now provide the repertoire for the kinds of normative and political claims that are being raised today. So just as you can draw a very straight line in Germany between the trade and employer associations that got founded in the late 19th century and that could really still continue to exist today, you can also draw a really straight line between the AABA and its immediate successor, the League for Industrial Rights, which was basically the same cast of characters with a different title, onto the American Liberty League, which was created in 1934, and which was literally just a vehicle through which to mount litigation and court-based challenges to the New Deal regulations. This was the outfit, among other things, that wrote the brief to challenge the Wagner Act in the 1930s, and right on up to the present strategies of the U.S. Chamber of Commerce National Litigation Center. And then finally, in terms of industrial relations, just to kind of circle all the way back to Forbath's important work on labor, the fact that employers did not develop strong capacities to coordinate their own activities in the labor market meant that they had huge incentives to make sure that labor also lacked these kinds of coordinating capacities, because otherwise you would have each individual firm confronting powerful collective labor movement on their own. So the Wagner Act is, of course, often characterized as a kind of big breakthrough or a reversal in the evolution of labor relations in the United States. But I think viewed against this backdrop, if anything, it really just represents a kind of culmination of these previous trends, because the way the law is framed really continues to discourage multi-firm coordination, really on both sides of the class divide, and instead really has helped to institutionalize this very decentralized and fragmented enterprise-based bargaining system that remains with us today. So I'm eager to hear your comments and to hear your questions.
Thanks very much, Kathy. That's very it's interesting and sweeping and important and provocative. So that's more than we can ask for normally on a Tuesday afternoon. I've got lots of questions, and I'm really keen to pose them to you. And if members of our audience have questions, we encourage you to drop them into the Q&A function, and then I'm happy to pass them on to our distinguished guest. Let's talk about the U.S. versus Germany, but I want to put the U.S. in a slightly broader framework, because there are these classic sort of classifications of countries in comparative politics, and normally we would classify the United States as being a liberal democratic economy, and people see more similarity between Canada and the U.S. and Australia and the U.S. That's a special case. The UK and the U.S. than they do between those other countries and Germany. So I know you're not. We didn't bring up here to tell us about Canadian politics, but what I want to get is your sense of how we understand this in the broader trends of deunionization, of deindustrialization, of the decline of collective bargaining and worker power that we've seen in other countries, in Canada, the United Kingdom, in Australia, though it was much more deliberate in those cases. I think, is the U.S. still a special case here, or is it sort of the extreme case of trends that are probably global and that are probably pushing on multiple countries?
Oh, that's a great question. I mean, a couple of different answers to it. The first is sort of on the like, is this a deindustrial or deunionization? That is really a common trend, as you point out. But part of what I'm trying to sort of underline here is that in many ways, certainly in the more egalitarian countries, employer organization is, if anything, as important, if not more important, to sustaining these more egalitarian outcomes than union membership. And I'll give the example of Germany, which in the meantime, union membership, like everywhere else, has declined. But in the meantime, union membership is down to about 20%. So it's pretty low. But employer organization remains high, so that collective bargaining coverage remains very high. So in these more coordinated systems, whether or not you belong to a union is actually far less important than whether or not your employer belongs to an employer association. And so that's why I'm sort of trying to put the focus on what is happening and has happened in the the employer side. The other piece to your question is, well, it may or may not be how does the U.S. fit into the other liberal market economy, sort of that whole cluster of countries?
Yes.
Is it distinctive also with respect to those other countries? And I think, I haven't done the full analysis here, but in looking at the approach of liberal countries, these liberal market economies, to antitrust in the period that I'm talking about, the U.S. really is distinctive.
Mm-hmm.
Britain, in Britain, there was the courts exercised a whole lot more forbearance when it came to combinations. I mean, in that case, the kind of critical or a critical court decision came in 1888, the Mogul steamship case, where the court basically said they had no problem saying, yeah, this is actually okay. It's up to this business to figure out how to manage themselves. So there's a way, and the same thing. I mean, Australia was also very tolerant of what we would call cartels. The Canadian case is really interesting. If somebody knows about that, I really want to hear it, because what I know is that they did do a kind of antitrust law, sort of along the lines of the Sherman Act. But what was also very clear, and what they made explicit in the Canadian law, and which makes a huge difference, I think, is that unions would be expressly exempt from that. And that was something that was never clarified in the American law, despite the fact that if you go back to the legislative record, it was clear that the legislators who brought the legislation meant for unions to be exempt, but that was not made clear, and that's one of the reasons that unions could get clobbered with this law in ways that were not possible in other countries. But so what I'm learning is that even among the liberal countries, and even among common law countries, the Sherman Act sort of froze things in a weird way, and in a way that was not true in other common law countries, up to and including the British case, where the common law continued to evolve, and the common law in general continued actually to exercise forbearance toward these kinds of horizontal combinations that I'm talking about.
That's very, very helpful. The other kind of the distinct feature of the U.S., certainly vis-a-vis Australia and the United Kingdom, is the lack of a labor party, of a genuine party of the left, which is associated not only with workers but with unions, and indeed with well, as a counterpart of employer organizations, actually, in a lot of respects. What is your sense then, though, of the causal ordering of that? And I understand it's probably very complex, but where does the lack of a strong left labor party in the U.S. fit into this story? I mean, certainly you can imagine it being a cause of their not being stronger unions, but also a consequence. So I wonder where it fits into this puzzle. And the second thing I would add to that is that I wonder if you can just walk us through the element of kind of the influence of the early welfare state in Germany, which relies largely on pre-existing organizations for its implementation and for its instantiation and for its realization. How much does that factor into this story as well? Obviously, that's been largely absent from the U.S. for a long time.
Right. Another great question. So, I mean, one of the things I think that we know from the comparative literature is that the strength of labor and capital sort of rise and fall together. And so it's not, and as I was saying earlier, that, employer organization is a sort of sine qua non. It's necessary, it's clearly not sufficient, but if you have disorganized employers, it's really hard to have strong labor unions. And so in which order did they develop? I mean, I think the fact I mean, one of the points that I'm trying to make, so German employers organized to do battle with unions, right? Let's be clear. They didn't love unions. They were hostile toward unions, just like American employers were hostile towards unions. The difference is that they did not have a reliable ally in the courts. And so what did they do? They had to organize themselves. And so what did they, and they too, of course, had every right to engage in collective self-help, which meant, you know, lockouts and so on. And so they developed repressive forms of coordination, but the key word here is coordination,
Yes,
right?
yes.
They developed these associations to do battle with unions, which of course, after, you know, sort of democracy, after the First World War, and with the turn toward democracy, could be converted to more cooperative arrangements. But if you didn't enter that period with strong employer associations, it was going to be very hard to develop any kind of strong union, a centralized union association, because, you know, when employers are disorganized, if they don't have those capacities, their strong interest is to keep unions fragmented as well. And that's exactly the outcome that we got in the United States, despite the Wagner Act. I mean, the Wagner Act basically institutionalized that settlement.
I mean, this almost becomes a very interesting, maybe you'll forgive me for the analogy, but it becomes it starts to look very much like a sort of repeated prisoner's dilemma game, where you've got two very strong players, and once they realize that they're playing against someone else who has a pretty strong defect option, they want to enforce cooperation. And once they're both geared up for battle, they might as well cooperate rather than trying to break down this system where they're both, you know, it's not clear who's going to end up worse off. We've got questions, and I want to shift to your work on the platform economy. And I want to ask the question. I'm thinking about ways to ask the question, but one way is this: is do you imagine that, you know, new forms of organizing work, new forms of people not working alongside each other but working at the same tasks, do these open up new opportunities to move some way towards both employers bargaining in much more coordination, but also workers having more power? Or do you think that this is one more step down the long road of things getting harder and harder for workers vis-a-vis their employers in the US?
Well, certainly in the US, I think I see, despite some new initiatives on the part of labor in terms of, and some new, you know, some signs of really interesting life, you know, we had some very successful teachers strikes in the South, no less. We have now an organizing drive among Amazon workers, which I think which Joe Biden just recently released a statement, really the most powerful pro-labor statement I've heard any president make, really going all the way back to FDR. But in general, I think I see the platform economy as an extension of a previous trend toward increasing precarity, because it starts with you know, firms offloading certain kinds of functions to suppliers or to franchises in order to avoid you know, high wages, but also to avoid various kinds of labor law. And the platform economy sort of takes that in many cases toward to its logical extreme, because there you're of course dealing with people who are not even classified as workers, and so you have absolutely no responsibility toward them. And so in the US, there are signs of life along the lines that I was just talking about. But at the same time, you know, Amazon and Uber and Lyft, they're extremely powerful. And, you know, it's not a coincidence that the referendum just failed in California on getting these workers classified as workers, because they have these kind of a strong alliance with consumers who really can be mobilized to support the position of these companies, even against workers. So I think it really requires, I can see some positive initiatives, but I think labor law reform is really crucial to sort of turning this tanker.
Yeah, what's the nature of that labor law reform that's going to give? So is it about universalizing protection of workers, and doing things like essentially trying to lift standards for workers across the board, under the logic that you're not going to be able to capture gig workers otherwise, so you've got to try to get these people classified as workers and then increase the minimum wage? Or is it about trying to come up with laws that are bespoke to platform workers or to gig workers to try to make them more powerful as a class?
Right.
Or is it something else?
Yeah, I think sectoral bargaining would be an enormous help, and a presumption of representation by unions rather than a presumption against it, and then these individual votes. I think those would be sort of the crucial things. I mean, there's a way in which regulating platform firms should actually be specifically, although that's a very tiny sort of slice of the working population, but for those firms, it should actually be pretty easy, because actually what you can do in the Swedish approach is to sort of embed in the algorithm the regulatory framework that you want to implement. So for example, Airbnb in Copenhagen, it's they have a rule there about I can't remember the exact the details, but it's something about you can't rent your house out for more than 3 weeks per year or 3 months per year or something. And it's in the algorithm that once you've done that, you're thrown off the platform until you're eligible again.
Yes.
And in principle, you should be able to do those kinds of interventions that operate that are self-regulatory. In other words, where you don't have to worry about monitoring, because the problem in the U.S. certainly, I don't know about Canada, but the problem in the U.S. is not just that we do have some laws to protect certain kinds of workers. The problem is that they're not enforced, and running afoul of the law in the U.S. is a minor business expense when it comes to violating labor laws. And so something that would be more self-enforcing like that would be another kind of solution.
Yeah, so that's very interesting, because then it comes up against, which was largely, I mean, it was articulated earlier, but it comes up against the challenge that these organizations like Uber, whether they're operating in Canada or in the US, aren't operating in one jurisdiction. They're operating in thousands, in fact, which have different rules, right? So Airbnb, to take that example, deals with different municipal regulations wherever it goes, and it has every capacity to tune itself up to those regulations. The question is, do those local places have the capacity to regulate, right? Is the first consideration. So for Uber, it seems like the steps are to first try to legally establish that workers are employees, right? And then to get into the business of starting to establish labor standards, because as soon as you do things like, come up with some Uber targeted rule about the number of hours that a person can drive, they'll simply just ramp down opportunities, presumably for that driver whatever driver is 1 hour away from being classified as an employee. Suddenly their app will stop working, or they won't have access to customers or something like that. So this is where it seems to me to be difficult politically. I'd love your reflections on this, that in fact, the number of people who are in the platform economy is much more than people who are working for the 4 or 5 companies that sit at the top of our heads when we're thinking about it. And trying to chase those companies on technology is always going to be difficult, because they're going to outsmart legislators at every turn, and then they're just going to tie things up in the courts. So I don't know I'd love your wisdom on this, but I don't know what the strategy on that is. Do you have a sense that there's a more general strategy? I mean, one that gets talked about, for example, is, the creation of portable benefits, some set of goods that you give to people by virtue of them being a citizen. You let them pay into them, maybe through some form of employment tax, but you give them that, so wherever they're working, they can carry those with you. Do you see those types of solutions as those types of things as part of the solution, or are they really, just enabling these companies to keep not doing their bit and downloading onto government instead?
Well, yeah, I worry about those kinds of solutions on their own, because they're, of course, what the government gives, it can easily take back, and so I think things would be on more stable ground if they were like if the solution targeted the power imbalances rather than just the sort of monetary aspects, and those power imbalances are simply only overcome. I think they can only be overcome through some form of organization. And you can certainly imagine, like there are huge collective action problems,
Mhm.
especially among these kinds of workers who are like scattered all over the world. But collective action is not it's not impossible to overcome this, and government interventions can be really important for this. Some of the most successful campaigns recently have been the Fight for 15, which is like McDonald's workers. It's hard to imagine a more vulnerable group of workers. And so I think, but I think those kinds of solutions could be a part of the problem. And certainly I think that in the U.S. certainly there are many steps that one could take that would just bring us into the fold of the rest of the rich democracies in terms of sort of minimum benefits like healthcare and so on. But beyond that, I really do think that there's a power imbalance that has to be addressed in a pretty fundamental way. And it is definitely a very knotty problem. The other thing that I think is really quite important is that, or the other reason that sort of addressing the power imbalance is really important, is because consumers are complicit for some of these firms, for the consumer-facing firms here, especially the platform firms. Consumers are really complicit in this, and it's really hard for individual consumers to to do anything in the absence of a kind of countervailing force exercised by workers themselves.
Yeah, no, I mean, this is very much on point, right? I mean, it's a bit far afield, right? But though I'm sure you're aware of it, but the recent kind of unilateral action by Facebook in their dispute with the Australian government to essentially pull down all news off of Facebook, but not only that, any kind of information source which they could say was plausibly linked to a news organization, completely impoverished people's basic Facebook experience during the 2 days that they did that. And that was really a show of, in my estimation, it was a show of strength, right? They sort of said, look, we actually matter a lot here. Consumers matter to us. Shutting down Uber suddenly in a city results in people who are upset because they now they've got to pay higher taxi fares again, rather than being able to pay rock bottom Uber prices. So there is that massive power imbalance there, which I think is, you're right to point out, is a really important one. I want to ask one more kind of political development question here, and I don't ask it because I ask it because it must matter here somewhere, which is, what's the role of race in America's struggle with race and its centrality to American politics through the end of the 19th century, through the Fair Deal, in through the 1960s? Where does that factor into this story of the imbalance between workers, the power imbalance between workers and employers, and where does it factor into the politics of this? Does it have any role, or are those things happening orthogonally to these developments?
No, I mean, the Americans. So I mentioned at the beginning of this talk that I've been working together with colleagues on various aspects of the American political economy, and one of the big themes in that volume is the way in which race, the American political economy, is shot through with race. I mean, it is present in all periods and across all every conceivable aspect of the American political economy. I mean, some of the things that we know about is the role of race and in sort of fragmenting and employers' deployment of race to fracture the to fracture the labor movement. But you know, the entire system of credit, which is extremely predatory for people at the low end of the market, the way in which credit is used as a or has been sold as a kind of alternative to you know, actual redistributive state redistributive politics, the whole carceral state. I mean, there's no feature of the American political economy that is not touched by race. And you know, it does start obviously in the period that I'm talking about. It starts from the fact that you have the growth of a national product. You know, you have the knitting together of a national economy. But characterized by two very distinct sub-political economies. One which is based on sort of after the Civil War is still based on low wage and sort of a racial hierarchy, and the other sort of based on a completely different outward orientation toward industry, and the conflicts that began then and that were never resolved, certainly not in the progressive era, definitely not in the, they were in many ways instantiated in the New Deal with the way in which labor's rights were institutionalized, which specifically excluded domestic workers and agricultural workers as an express, you know, sort of concession to the South. There's no aspect of the American political economy that is not touched by by the politics of race and racial hierarchy.
Let me ask one more question, and I ask it to you as a citizen of the U.S., but also as I think one of the preeminent scholars of the history of American politics and the development of American politics. Do you? But it'll be a personal question as well, so I apologize for that. Are you hopeful about the United States? And what are the sources of hope, and what are the sources of ongoing concern? And I don't ask it to be cute. I ask it because it seems like we've reached some critical moments in the U.S. in the last decade, and certainly in the last 4 years. And I want to get a sense of, I'd be remiss if I didn't, from someone who has such a grand view and so many lines of sight into the U.S. What are the sources of hope? What are the sources of concern, and what direction is this thing going?
Yeah, it's really interesting. If you would ask me, you know, a year ago, it would have been a pretty hopeless answer. I would say I'm sort of guardedly optimistic. I mean, it's hard to be unequivocally optimistic. I'm optimistic because as much as you know, Biden wasn't like the first choice of very many people, but once he in the primary period, but once he assumed the presidency, he has done some pretty good things, and among other things, he's appointed a couple of my really dear friends and collaborators to positions of power within the administration, and this gives me some hope. At the same time, I am really, it does give me great pause to notice the extent to which the kind of, you know, racial resentment and the whole sort of the sort of rural backlash is so resilient and so deeply embedded in the current period. And so while I'm not as worried as I was a year ago about Democratic backsliding, although I think that's always still a possibility, I am really worried about that. And the other thing that I will say I am really worried about is the courts, because I think the courts are an enormously important and very understudied institution that is really hugely important, maybe distinctively important in the American context. And there we are talking about a court system that has been absolutely transformed over the past 20 years through the sort of appointment en masse of a bunch of conservative jurists who will be there, who are young and who will be there for a very long time. And this is even net of the, sort of not to speak of the Supreme Court. And that is sobering to me because, you know, that's a legacy of this immediate previous period it's not just going to be with me for my entire lifetime, but it's likely to be a part of my kids' lifetime as well. So those are that, and in addition to climate change, those are my big worries. And they're still pretty big, even though I'm a little less pessimistic than I would have been a year ago.
Yeah, certainly they're not going to be solved in the next 4 years. So it's a long struggle ahead. Kathy, I want to thank you very, very much for joining us. Before we do that formally, I do want to just say thank you very much to the staff at the Munk School who do such a great job of helping us put on these events. I want to thank Paul Cadario for his great his friendship and his great sponsorship of this lecture series and so many other things at the University of Toronto. And I wanted to thank Carolyn Toohey, who has been organizing and has been the leader of the Cadario lecture series for so many years and has done it so graciously and so well. Finally, Kathleen, let me just thank you very much for joining us. And you know, it's a real honor when a scholar is willing to come and speak to us, but it's particularly so when they're willing to share with us what they're working on now and what they've been thinking about, because it's like sharing your most important work and the thing that you're laboring on with other people, and you can't give people anything more valuable than your labor. So we really appreciate your being with us. We wish you could be with us in person, obviously, but as soon as airports open up sometime in 2028, we'd love to have you back to the University of Toronto. In the meantime, thank you very much, and thanks to everyone who attended the Cadario Lecture in Public Policy with our distinguished guest, Kathleen Thalen. Thank you very much.
Thank you. Thanks. It's been a pleasure.